All right, so Roger is just a great writer. He is a professor emeritus of the University of South Dakota. He's actively been involved in ERISA reimbursement litigation and has participated in 4 United States Supreme Court cases involving ERISA reimbursements. He's authored 3 significant law review articles as well as numerous bar journal articles which deal with subrogation issues in the context of personal injury claims. And by the way, I'm assuming that's why we're all here today, right? His Mercer Law Review article on ERISA reimbursement has been cited by 3 federal district court judges and opinions handed down in Illinois, New Jersey, and Washington. He has been litigating ERISA liens in state and federal courts across the country for more than a decade. And among other cases, he has successfully defended an action brought against a New York attorney and his client in 2012 in the U.S. District Court for the Southern District of New York, appearing lead counsel pro hoc vice. In 2017, the Supreme Court of Hawaii cited and relied upon his article in fending off efforts by a health insurer to undermine Hawaii's protective legislation. ERISA health insurers next brought a challenge to the same litigation in federal court. The U.S. District Court in Hawaii ruled in favor of the tort victim. They took an appeal to the U.S. Court of Appeals for the Ninth Circuit. Professor Barron assisted the lead attorney in the Ninth Circuit briefing and also helped prepare him for oral arguments which took place in Honolulu this past June. The Ninth Circuit handed down a favorable decision just 2 months ago on September the 11th. Roger's been a very reliable, I would say, combatant on the plaintiff side and a field general, really, in giving me advice on occasions. And I have nothing but wonderful things to say about a very good-hearted man who sacrifices his time for the benefit of all of us. Many of these cases he doesn't get fair compensation for. So with no further ado, I introduce Professor Roger Barron.
As a result of law review articles that I published in the 1990s, I began receiving requests to get involved in ERISA subrogation litigation. In 4 of the cases in which I have been involved, the issue has risen to the level of the U.S. Supreme Court. My first involvement was in the case of Reynolds Metals Company versus Ellis, shortly after the Supreme Court granted cert in November of 2000. This case was ultimately resolved by agreement of the parties after cert had been granted. My second involvement was in Sereboff versus Mid-Atlantic Medical Services, decided by the Supreme Court in 2006. I assisted in the briefing in the Supreme Court proceedings and also assisted the lead attorney, Peter Striss, in preparation for oral argument the day before it was argued. I was present in the Supreme Court courtroom in Washington, D.C. when the case was argued. My third involvement involved the case of Walmart versus Schenck, a case presented to the Supreme Court in 2008, and this case is the primary subject of this video. My fourth involvement was in U.S. Airways versus McCutcheon, decided by the court in 2013. I co-authored an amicus brief filed on behalf of 7 trial lawyer organizations across the country and also on behalf of United Policyholders, a consumer protection organization. This video presents an explanation of the Walmart versus Schenck situation, my third experience in the Supreme Court arena, which was resolved in 2008. The next time I got involved in a case was about 4 months after the Sereboff decision. There was a trial court decision in Missouri in Walmart versus Schenck. And I was not involved at the trial level. I wish I had been involved, had the opportunity to be involved in the trial level. It was an adverse decision by the trial court. That was appealed to the 8th Circuit Court of Appeals, heard by a 3-judge panel, also an adverse decision. I was involved in the briefing of that. We filed a motion for rehearing in bank in the 8th Circuit. That was denied, and so we filed our petition for writ of certiorari in the Supreme Court. That was eventually denied. The day the court denied cert, I'm going to show you a couple video clips. The first video clip comes from CNN. It tells the story of Walmart versus Schenck. This story aired the day the court denied cert.
I was inspired by very sexy.
Debbie Schenck remembers an account in German,
but she has no idea what she had for breakfast or what my name is minutes after meeting me. Debbie has no short-term memory. In May of 2000, a semi-truck plowed into her minivan on this Missouri highway. Debbie's brain took the brunt of it.
It came through her window and probably hit her head.
I remember.
Today, she lives in a nursing home. Jim Shank works 2 jobs to help pay the bills, and his bank account may soon take another hit. 8 years ago, when she started stocking shelves at this Walmart near her home, Debbie signed up for the company's health and benefits plan, so she was covered, and her family says the bills were paid promptly. What Debbie didn't notice, her husband says, is a tiny clause in the plan's paperwork that says Walmart has the right to recoup medical expenses if the employee also collects damages in a lawsuit. In 2002, the Shanks settled with the trucking company. After legal fees, $417,000 was put in a trust for Mrs. Shank's care. The family's lawyer says he told Walmart about the settlement. Then in 2005, Walmart's health plan asked for its money back and sued the Shanks for about $470,000, money it had paid to cover Debbie's medical bills. The court ruled in Walmart's favor. The fact is Walmart isn't doing anything wrong here. It is their legal right to recoup this money.
They're quite within their rights. But I just wonder if they would need it that bad.
We tried to ask Walmart why go after the money. The company's net sales, third quarter of 2007, were $90 billion. A Walmart spokesman who called Mrs. Shank's case unbelievably sad told us, Walmart's plan is bound by very specific rules. We wish it could be more flexible in Mrs. Shank's case, since her circumstances are clearly extraordinary. But this is done out of fairness to all associates who contribute to and benefit from the plan. Do you think Walmart should make an exemption for your family?
My idea of a win-win, you keep the paperwork that says you won and let us keep the money so I can take care of my wife.
If Walmart's health plan gets the money back, Jim says he won't be able to pay for his wife's care or his own. He's recovering from prostate cancer. He may lose his car, and he won't be able to send his youngest son to college.
Who needs the money more? A disabled lady in a wheelchair with no future whatsoever? Does she need it, or does Walmart need $90 billion plus $200,000?
The Shanks lawyer says Walmart is entitled to only about $100,000. Right now, about $277,000 remains in the trust, far short of what Walmart wants back.
Oh, that's one she got you for Christmas.
Last year, Jim divorced Debbie so she could get more money from Medicaid. The trauma to Debbie's brain was so severe, Jim says she won't remember we were here visiting her. In fact, she doesn't even remember the accident that put her here. She's in a private room for now due to severe mood swings and a tendency to scream, all related to her injuries. But she may not be able to afford her own room much longer. Last summer, the Shanks appealed the ruling in Walmart's favor and lost. 1 week later, another terrible loss. Their son, 18-year-old Jeremy, in Iraq just 2 weeks, was killed. Debbie went to the funeral, but doesn't remember her son is dead.
What?
When reminded, it was as if she was hearing it for the first time. One final push is underway. Jim is petitioning the U.S. Supreme Court to hear Debbie's case. What's left of Debbie's trust will remain frozen as the battle rages on. Randy Kay, CNN, Jackson, Missouri.
Keith Overman started running Walmart as the worst person in the world on consecutive days, beginning 9 days after the denial of the petition for writ of cert. And he vowed to continue to run the story as Walmart as the worst person until Walmart gave up in the case.
And our winner is Walmart. Nearly 8 years ago, a Walmart shelf stocker in Missouri got broadsided by a semi. Deborah Shank, now 52, is brain damaged, in a wheelchair, in a nursing home. She needs 24-hour-a-day care. She got $700,000 in a settlement from the trucking company. After attorney's fees, $417,000 was left for a trust fund to make her shattered life a little bit better. And Walmart promptly sued Mrs. Shank for the money. Because, says spokesperson Weber, Walmart's health plan says, and your company's plan may also say this, you better check. If you get really hurt and you receive damages in a settlement, Your employer can sue to get back anything it paid you for your treatment. So they sued this woman who had $417,000 for $470,000. Now, contrary to general opinion, Walmart is not owned by the devil. Its stockholders are not uniformly horrible people. The stores often do not destroy, they sometimes even improve communities. But you know why people think of Walmart and evil in the same sentence? Because of the crap you guys do like this. Instead of letting this one go, and maybe even putting out a press release saying, we take care of our own. Maybe you get $470,000 worth of good publicity. No. Now you get this. Walmart's profit last year was over $11 billion, including $470,000 it got back from Mrs. Shank, who is, between the truck that hit her and what you amoral Walmart trolls did to her, she is so confused that she doesn't really understand that 6 days after you beat her in court, her 18-year-old son was killed fighting for this country in Iraq. Walmart, may your stores melt in the hot sun. Today's worst persons in the world.
As a result of the public outcry for justice on behalf of Mrs. Shank, Walmart relinquished and allowed Mrs. Shank to keep the entire recovery. Walmart also amended the terms of its plan documents so as to provide accommodations for future victims, such as Mrs. Shank, in hardship cases. Under the new terms of its plan documents, petitions for relief are submitted to a designated committee. During the years subsequent to Walmart's decision in 2008, I have assisted various attorneys in making and submitting petitions for waiver to the Walmart's committee. In each of these cases in which I've been involved, Walmart has provided a complete lien relinquishment, with the most recent relinquishment occurring in early 2019. A detailed history of my involvement in the Walmart versus Shank proceeding has been documented in an article written by my associate, Marilyn Treves. Marilyn's article meticulously traces the interactions between Mrs. Shank's primary counsel and myself, as well as the numerous communications with members of the media. The spark for the national outcry for justice began with a front-page story in the Wall Street Journal, and Marilyn's article traces 7 weeks of intensive email exchanges and phone conversations with the Wall Street Reporter. Marilyn's article is entitled Public Pressure Reverses Adverse ERISA Result for Deborah Shank, and it was first published by the Kentucky Association for Justice in its journal. That article may be viewed and downloaded at my website. Go to ERISAwithProfessorBarron.com. Click on the link to the U.S. Supreme Court cases. The discussion of Walmart versus Shank is in the first paragraph, and Marilyn's article is linked in this paragraph, together with a link to Walmart's letter describing how its plan documents have been modified. Thank you, Michelle. Thank you, Paul. I'm very pleased to be here. I thought I would just read a statistic. I recently signed an amendment.
Sorry, I figured it out.
I gotta use the bathroom, man.
Getting away from the speaker.
Hi. Oh, look at that. Okay, great. Don't put this anywhere near that speaker or you will scare. Hang on, I'm going to turn it down.
That helps. Okay.
Okay. Thank you. Sorry.
So that's for this room. I don't have to speak loudly. Okay.
Sorry.
All right, we'll try this again. I recently signed a brief that I did not author but signed onto it that was filed in another ERISA case, not subrogation. But I noticed the statistic that the person, and this is in the Supreme Court, provided, and I wanted to grab it. It comes from the United States Department of Labor website, that currently ERISA covers, the ERISA provision of healthcare plans covers more than 141 million participants and beneficiaries. So in terms of where your healthcare coverage is and what laws it's governed by, 141 million in the United States, according to this fact sheet on file with the United States Department of Labor. And statistics confirm that the subrogated recoveries received by these health plans exceed $1 billion per year. I first found that statistic in the Sereboff case when the amicus brief was filed by the United States Chamber of Commerce trying to protect the ability to collect subrogation, and they of course cited that statistic, and it's been cited a number of times, and so if anything, it's larger today because the law has become more adverse to the victims as a result of that. All right, let me see. I don't know if, can I lay that here? Does that work if I lay it down? Okay, that's the room mic, and I got that mic, and I'm not going to travel. Okay, Paul Isaac, thank you for being a longtime friend. Okay. And ally. I worked with Paul for quite a while, and there we are going about the town last night. My wife's not in the picture because she took the photo, so thank you for that event. And John Bosco, my longtime friend, is here from Staten Island. He's been on my email list for a number of years, and I'm glad to see John here. I have an email list where it's a blast list, and I send out developments in this area of the law when they happen. So you all are free to sign on to it. Just send me an email, and I'll be glad to add you to the list. There's no charge or anything like that, and you just get to read. I tend to report primarily the favorable developments, but I do report a lot of things on my email blast list, and I know John's been on it for over a decade, I believe, and we've been connected. John from Staten Island there. Okay, get that. All right, if you're not old enough to remember Elizabeth Taylor, she was a great actress, and she had 8 husbands, and she was, I think, more famous for her husbands than her acting, but she did have many husbands. And I like to think about what my work here today is how perhaps Elizabeth Taylor's 8th husband felt the night of the honeymoon. I know what I've got to do, and I just hope I can make it interesting, you know. So that's the goal here. The Walmart versus Schenck story has a happy ending, and Walmart has changed its plan, and it's a huge, huge employer. But the law created by Walmart versus Schenck has not changed. All of those cases, all of those decisions are still out there, and they're adverse. They're adverse to everyone else. And I was recently involved in a case in Missouri where we had the Walmart versus Schenck case cited against us. We were litigating an ERISA lien. I'll talk about that case in a little bit. We're litigating an ERISA lien in Missouri State Court. I was able to get that case filed in state court and stay there, made it non-removable, and the other side's primary source of authority was Walmart versus Schenck. And it just, I don't want to be cynical, but it never ceases to amaze me how many lawyers just cavalierly walk over this ERISA lien and think the law is somehow going to protect them. And it doesn't protect you. It doesn't protect your client. The law is about as adverse as it can be in these matters. There are things we can do to try to make the best of the situation, but almost always the things that we could have done to make the best of the situation have already been done adversely in the other way. So the dramatic impact of the law of is everybody hearing me okay? Okay. All right. Is it on? It's not on. How do I turn it on? I'll get you. Will that project into the room? Yeah, please. Okay, we're going to do it that way. So the law's still there. When I get involved in cases, there are 3 different stages of involvement that can occur. And the first stage is as soon as the case walks in the door. And I have a handful of lawyers who will get me involved in a case that they know right up front that a huge ERISA lien is out there and they want to deal with it. And that is where I can be most effective, me or somebody like me who's working in this area. What I call the next stage of involvement is better than the last stage, and this happens a great deal, but where the plaintiff's attorney is on the verge of settlement, have not released the tortfeasor yet, and haven't collected the settlement funds. We can be very effective at this stage, but once the tortfeasor is released, and once the settlement funds, should I hold on to it?
If you like.
Okay, thank you. Got 2 hands. Once the settlement funds have been received and the tortfeasor is released, what you've done is you've put the client in terms of the breach of the plan contract. That act puts you in a breach, and now the attorney and the client are ripe to be sued in federal court for breaching the terms of the plan contract. And it's very, very difficult to be any good in that last final situation. In that second stage, where the tortfeasor hasn't been released, there is a lot that we can do. It takes a little bit of time to do it, 30, 60, 90 days, maybe a little bit more. And usually I'm able to persuade the plaintiff's attorney to not finalize, not issue a release and not receive settlement funds. And because the law has changed so much more so adversely, especially as a result of the McCutcheon case, that's the most recent Supreme Court decision that really is detrimental. I don't even get involved in these cases most of the time. When attorneys contact me and they say, I've released the tortfeasor and I got a settlement, funds in my bank account and Rawlings is getting ready to sue me, I just say, I'm sorry, I just can't help you at this point in time. Now, there are a few exceptions to that. And I just had one of those exceptions occur about a month and a half ago. And this happens because the attorney and his client was sued in federal district court in Western District of Washington in Seattle, and I'm representing him in that claim. And we have a few arguments that are good, and we have what appears to be a nice, fair judge on the case. But my life is just much easier if I don't get involved in these cases. You've taken away all of my tools. I have tools that I can invoke to help you. But once you put yourself in breach of the terms of the summary plan description or the plan document, those tools have been eliminated. Another thing that's really important, I tell you what, why don't we, we're going to have a break here in about an hour, and if you have questions, why don't you write them down and give them to me at the break, and I will answer all of your questions as best I can. And at the conclusion of the overall presentation, I'll open it up for Q&A. So that's how I'd like to handle the questions. So we'll take about a 5 or 10 minute break after about an hour, and then I can receive some of those questions. I want to make sure you understand what I call the self-help remedy. Those are my terms. You don't really find it anywhere out there. But what happens, and this is very similar if you're involved into litigation involving long-term disability payments or short-term disability payments, what the disability insurer will do will hopefully will start off making your payments that you're entitled to when you suffer the disability, and then it requires you to apply for Social Security. And then once you qualify for Social Security disability, you usually get a lump sum payment by the time they make that decision. So that lump sum payment might be $80,000 or so. And so as soon as you receive that lump sum payment, your long-term disability insurer says, we're entitled to that. And what it does is it quits making monthly payments to you, or it may pay you $100 a month. By you, I mean the insured. And it pays itself back until it's recouped all of that $80,000 that you've been paid. And so that same scenario, if you're familiar with that, that same scenario happens here, where the ERISA health insurer, once it finds out that you received a settlement and the employee is still employed receiving health care benefits, it will no longer pay health care benefits to pay itself back. This phenomenon happened several years ago, but it still happens today. But in a period of 6 months, I've received inquiries from 3 attorneys in 3 different states. One of them was from an attorney who used to be a judge. I actually met him, is in Kansas. And each one of these attorneys had the same scenario. They had a client who had a bad accident, motorcycle accident, had catastrophic injuries, and all they could collect was $25,000, the minimum liability limit in that jurisdiction. And they went out and they collected that $25,000 right away. You know, not a great lawyer, not a great difficult lawyering job to do that when they want to hurry up and pay the policy limits. And in each one of those cases, they collected the policy limit before the health bills had even been paid by the ERISA plan. So the medical bills started coming in. The ERISA plan knew that there was a $25,000 payment from the tortfeasor's liability company. And so each one of these cases, the plan said, we're not going to pay the first $25,000 in medical bills because and this is written into the plan document, and we have the right to pay ourselves back. And so these lawyers, you have to ask the question, how how effective were they for their client when they rushed out and got a settlement, may have taken a third of that or certainly a portion of that settlement for the attorney's fee, and now the client is going to suffer a loss of $25,000 in medical coverage, and plus has paid that attorney fee. So that's the self-help remedy. If there's another file I had that I was actually working on in Missouri, same sort of situation, but in this case, the wife was injured, the husband was the employee, and they had children. So there's 4 people insured under this plan, and the plan took the position, because there was a settlement, we're not going to pay not only the wife's medical bills, we're not going to pay the husband's medical bills, we're not going to pay the children's medical bills. Everybody insured under that employee's coverage had their medical bills. We resolved that eventually, but that's what was lying ahead, is the loss of your medical care coverage in order for the plan to pay itself back. So you have to be very careful in how you operate in developing this strategy. So one of the first questions that there's a lot of first questions. One of the things I want to mainly emphasize is you can't talk about this topic in a 30-second soundbite. It's complicated. It really is. And that's why I like to show that video, just to tell the simple story of Walmart versus Schenck. You know, took several minutes, and there were professionals that were able to do it that way. But that's one of the questions you have to ask. Is this employee still employed? Because that differs. If I have a client that has an employee that's no longer employed, then we might be able to do things and invoke strategies where the plan won't be able to threaten us with the loss of health care coverage. ERISA is literally hundreds, probably thousands of statutes. I haven't counted them. But if you go to the United States Code, annotated United States Code, you'll find that there are 5 volumes devoted to ERISA. And if you were to search those statutes, you will find there's not a single statute that discusses subrogation or healthcare or reimbursement. It's not in there. And I didn't discover this on my own by doing the search. There is federal appellate authority that recognizes that. And so these are citations from 2 courts of appeals. ERISA says nothing about a subrogation provisions, neither requires a welfare plan to contain a subrogation clause, nor does it bar such clauses or otherwise regulate their content. So you cannot say, an attorney for a plan cannot say ERISA authorizes subrogation. It does not do so. It does not talk about it. And fortunately, I picked up a 3rd case. The Ninth Circuit said similar things in a decision handed down 2 months ago. This is the case I went to Honolulu with. And the Hawaii statutes only impact the insurer's subrogation rights against a third-party settlement. There are no statutory provisions of ERISA that address reimbursement. And sometimes my job causes me to travel to distant places, and so that was a pleasurable trip in Honolulu. I got contacted by Alan Williams, who is the lead attorney there, and the Ninth Circuit, you know, as the courts of appeals do, they travel to different places, so they hear their Hawaii cases in Honolulu. And the Ninth Circuit Court of Appeals courtroom in Honolulu is actually in the bankruptcy courtroom. And anyway, we had fun on that trip. Now, what I've been doing lately in terms of effective thinking and strategy that's panning out in the last couple of years is looking for forum selection clauses in the plan documents. And I had a case that I was still involved in Missouri. And we won at the trial level. And the forum selection clause is on the screen there. It said, and almost every ERISA plan has this language in there somewhere. It's a backdrop. It's what state's law the plan wants to apply if federal law doesn't control. And so this plan said, if ERISA or another federal law does not apply, the plan is governed by and subject to the laws of the state of Missouri. Missouri prohibits subrogation on personal injury claims. And so the attorney, and I've worked with him on a couple of other files. We have a good working relationship. He always pays me handsomely, which I like. I had him, he showed up for 4 hearings in front of the state court trial judge. We brought the plan into state court on an order to show cause. An order to show cause is not removable, and ERISA allows litigation of these issues in state court. The trick is you want to avoid having it removable. So you can't sue the plan as a defendant because it's removable by a defendant, but it's not removable by a recipient of an order to show cause. So anyway, Steve went into federal court, or state court. I said, Steve, here's what I would do if I were you. I would take these statutes into the courthouse. And he did. And he took these 5 statutes, he set them on the table, and when the first argument began, he said to the judge, Judge, here is ERISA, because a lot of state court judges don't know a lot about ERISA. Here are the statutes on ERISA. There is nothing in this statute that allows them to seek subrogation. And I invite opposing counsel, and there were 2 of them there, opposing counsel to find and show to you, Your Honor, any statute that allows subrogation. And believe it or not, during the course of this argument, which lasted about 45 minutes, one of them picked up the statutes and started looking through it and couldn't find anything. That was very effective. And each time he went back for the argument, we finally got a decision. And so the judge held, as a result of this language, typically where state law is preempted, the language itself reincorporates Missouri law because there is no federal ERISA or federal law that provides subrogation. I've got a case, so let's see. So he had that decision right after the Honolulu case got decided by the Ninth Circuit. And so that was good news for us, and it is on appeal. So I have another file, and I talked to Paul Isaac about this, who talked to Paul, the other Paul, because it's a Wells Fargo plan, and this is an active file of mine right now. Wells Fargo is a very large employer, not quite as large as Walmart, but it's got multiple versions of its plan in virtually almost all the states. I don't know so much in the eastern part of the United States, but in the western part. And its plan provides, we found it wasn't in the summary plan description, is in the plan document. It took us a while to get it, but it provides, except to the extent that federal laws controlling this plan statement shall be construed and enforced in accordance with the laws of the state of Minnesota. Minnesota follows the make whole doctrine. It followed it first by the Supreme Court of Minnesota by stare decisis, and then the legislature enacted it by statute. And so that was really good for us. This was a medical malpractice case in South Dakota, and South Dakota does not have favorable law. The only relief you get in South Dakota is the common fund doctrine. So this was like tremendous news, and we kind of found it at the last minute. And so now our position is, in this case, the same as it was in Missouri. If you take a look at these federal statutes, nothing authorizes it. All right, so let's go back to the bigger question. Why isn't subrogation or reimbursement addressed in ERISA? And then the question, who makes the rules? Well, when ERISA was enacted in 1974, and before that there was a decade-long study by Congress, investigative committees. And when it was enacted, subrogation by health insurers was prohibited everywhere in the country, not allowed. And the reason being, it was prohibited at common law. There are a couple of reasons at common law principles. You had subrogation on property insurance. If your house burned down, you could have subrogation there by the insurance company. But at common law, subrogation on personal injury claims was prohibited because it was viewed as an assignment of a personal injury claim, and that's against public policy, and it was viewed as splitting a cause of action. So there's a couple principles there, and they were entrenched in the laws of every state. So never allowed. So in 1974, when this ERISA was enacted, there was no such thing on subrogation on personal injury claims by a health insurer. So let's talk about who makes the rules. This is interesting history. At least I think it's interesting. I can't see the date, but it's in the 1800s. The Supreme Court handed down a decision that said a contract of insurance was not an item of interstate commerce. And the impact of that decision was that Congress could not regulate insurance. Congress lacked authority. And I think it's still true today. I learned in law school, and I think it's still true today, that when Congress enacts legislation in a civil area, about 90% of all of its authority is found in the Interstate Commerce Clause. And so when the Supreme Court said a policy of insurance was not an item of interstate commerce, Congress did not have the ability to regulate insurance. So what happened was every state began regulating insurance and regulating it intensely. Every state has a division of insurance. Some of these divisions of insurance are quite large in terms of personnel. Some have 1,500 employees. And every state has volumes of their code that regulate insurance. And the code, they also have insurance regulations. So insurance is regulated, and that's how it's developed historically on the state level. Well, 80 years later, this old decision was overruled, and it was kind of silly now that you think about it in modern days. Obviously, a policy of insurance is an item of interstate commerce. So in June 5th, 1944, the United States Supreme Court reversed itself first one is Paul versus Virginia, and this is United States versus Southeast Underwriters Association. So as a result of this decision, and there was actually a motion for rehearing filed, so it didn't become final until like November of 1944, but as a result of this decision, Congress could start regulating insurance if it wanted to do so. Okay. But if you think about history, the next day, June 6, 1944, was D-Day. So all of a sudden, the United States was involved not only in a war in the Pacific, but in a war in the European theater. And we were massively engaged in World War II. Now, in that background, Congress really wasn't interested in going and figuring out how to regulate insurance. Congress had pretty much on its mind, and the topic of the day is World War II and what can be done to support it. So there really wasn't the ability to regulate insurance by Congress. And you think about, today we think about the internet, email, and all that. In those days, you didn't have those luxuries, and so it just would be really difficult to do that. So what Congress did is it very quickly enacted the McCarran-Ferguson Act. This is a very short statute. You can fit it all of the terms of it on one page, one 8x11 piece of paper. And what the McCarran-Ferguson Act said, and it's still on the books today, is Congress recognized that the continued regulation and taxation by the several states is in the public interest. And nothing that Congress is going to pass, unless we specifically say so, speaking on behalf of Congress, shall interfere with the states. So states continue to regulate insurance, and they do so with the endorsement of Congress by the McCarran-Ferguson Act. That's because historically that's how regulation developed. So states regulate insurance by statute, by the Division of Insurance, and by regulation, and by case law. A lot of the law you get, especially in the area of subrogation, is common law determined by the highest court of the state. So when ERISA came along in 1974, and it was preceded by a decade-long congressional study, ERISA was not originally designed at all for health and welfare benefit plans. ERISA was designed for pension plans. And an extension to health and welfare benefit plans was just added more or less at the last minute. And so the way ERISA operates, which is this massive scheme, and most of us are familiar with it, we have this very broad preemption, massive preemption, and there's three clauses that operate. One's the preemption clause, which basically preempts any and all state laws. And then we have the saving clause, which is very important because the saving law will provide that state laws that regulate insurance still apply to a person who is an insurance company. So an entity that's an insurance company still has to comply with state law. That's very important in my area of the work. I want to argue the saving clause applies state law many times. And then you have the deemer clause that says the plan itself or a trust shall not be deemed to be an insurance company. So I don't want to get bogged down here, but as you look at these three famous clauses in ERISA, the preemption clause, you can actually win some battles here. And I've got some authorities where courts have decided that favorable state law is not even preempted. And one of those areas involves minors, and according to some of these, and so I'll talk more about that. So I've listed a few of the areas here where they're just kind of weird areas. Of course, you're going to be in the context of a situation where an ERISA plan says we're entitled to our money, and you have a favorable state law, and you might win that battle by saying this particular state law isn't even preempted. Now, those victories are very few and far between, but they can happen by litigating under the preemption clause. By far, the most effective strategy is the saving clause that says nothing in this subchapter shall be construed to exempt or relieve any person from any law of state which regulates insurance. And so an insurance company has to comply with state law in an ERISA setting. And so now I kind of want to take a little bit of a sidetrack, and I go back to the fact that at common law, there was no such thing on subrogation on personal injury claims. And beginning in the 1960s, there were efforts by automobile insurers to subrogate on the medical payments provision of an automobile policy. So today that may be $5,000. In those days it was $500 or $1,000. And so in conjunction with getting paid back for the damage to the car, that's subrogation on property insurance, automobile insurers were seeking subrogation on the medical payments provision. So each state now was put into the position of having to decide whether or not it's going to allow subrogation on a personal injury claim. And there's a body of law in each state, some very favorable, some not so favorable, and then just a vast range in between, a spectrum of the laws of the states concerning whether or not subrogation on personal injury. Some states, such as Missouri and Arizona, never allowed subrogation on personal injury claims. And to this date, they don't allow it because they still adhere to the common law view that it violates public policy. And so, as you look at, before I even got involved in ERISA, I published this article in 1996, and it's been cited more than any of my articles, but I discussed the spectrum of the different rules that have evolved on a state level. And at that time, this is kind of very superficial because there's many more rules today, but you could have a jurisdiction that outright denies subrogation, such as Missouri and Arizona. Kansas does that too by insurance regulation. You can have the May-Cole doctrine, which is the most favorable if you're not going to have an outright denial. You can have a doctrine called pro rata loss sharing or equitable apportionment. And equitable apportionment, that if you're familiar with the Allbarn analysis that takes place in Medicaid, which Allbarn established, Supreme Court reversed, Congress reenacted, so we're living under Allbarn now. It basically says this pro rata law, it doesn't apply in New York, so maybe I shouldn't waste time to talk about it, but very quickly, pro rata analysis is, okay, what are your real damages? My real damages are $1 million. How much are you recovering? $500,000. So you're collecting 50% of your real damages? Yes. Okay, so we'll pay back the health insurer 50% of its claim. So whatever that pro rata loss sharing is, if the insured collects X percentage of his total damages, then we pay back the medical bills at X percentage. That's better than what takes place under ERISA. And then the final one is the common fund theory, which is common fund is you have to make the insurer pay its share of the attorney's fee. In other words, at common law inequity, common fund was if all of us in this room are entitled to some money, but we don't all sue, and I bring an action on behalf of all of us, and if I collect money for everybody in this room and we're successful, but I have to pay an attorney 1/3 of everything, you have to pay 1/3 of your share. So common fund is you have to pay your share of the attorney's fees. It's specific for attorney's fees. That's what it's specific for, is a common fund. Each person that receives money on it. So the health insurer, you may have a health insurer who's processing a $300,000 claim for reimbursement, and if the attorney's fee is 1/3, you only have to pay him back $200,000. So those are some of the ideas. There are other things out there. Actually, the May-Cole doctrine breaks down into a couple different things. In jurisdictions, there's different rules out there, but in applying the May-Cole doctrine, if the insured collects $500,000, do you say, does $500,000 fully compensate the insured? Is he made whole? If not, you deny subrogation. A more favorable version is you look at what the insured actually receives after the insured pays his attorney fee. So if the insured receives 2/3 of $5, then so those are just variations. There's different rules. Or I spoke for the Oregon trial lawyers. One time I was invited there, so I did research on the Oregon law. Oregon has what's called a make-half statute. Not make whole, but make half. And what it does is it subtracts out, when you ask a question, are you made whole, it subtracts out damages for pain and suffering and other non-pecuniary damages or something like that. So it says, okay, if we don't include what it costs to make you whole for pain and suffering, are you made whole? So it's a modified version. Kansas is just kind of interesting because it takes the regulation by an insurance regulation. And I've spoken twice in Kansas on this topic, so they're like Missouri and Arizona. You just flat out and like New York also, you're just flat out not allowed to have it. California's got a weird one there. And so New York, as you know, has a statute that says that if you have a settlement, it's presumed not to include medical bills. And you are allowed to reach a settlement with a tortfeasor, and you can't be held in breach of any kind of provision with your health plan. And the reason New York has that statute is because of the collateral source rule, you're not allowed to collect medical bills. And so that's the rationale. Since these settlements can't include medical bills, you can't. But this also was challenged by the ERISA plans. So, the collateral source rule is that as you go to trial, can you tell the jury that these damages you're claiming have been paid by a collateral source? And so the collateral source rule allows the jury to be told you've been paid by your health insurance. So the way New York law operates is that we make health insurers pay their bills, and the plaintiff can't collect those in a trial. And so that's out of the process. So that's how New York handles that. So once again, that little summary at the time was been greatly enlarged on. Now, that evolution started in the 60s and the 70s, initially with respect to medical payments provisions, and has gone forth. Okay. What did I say there? Okay, Matt, I talked about that. So when ERISA was enacted, there was, I stand behind this statement, there was no subrogation on personal injury claims, period, in a health insurance context by health insurer. And the first reported opinion that I have found, and I've said this over and over again, and nobody has found anything earlier than this, the first reported opinion that shows an effort by a health insurance company to collect subrogation or reimbursement is this Massachusetts case, the Porter Leasing case, Frost versus Porter Leasing, and that was 1982, and that court denied subrogation. So what began happening was the health insurance companies, instead of doing business directly with insureds or policyholders, they moved into health and welfare benefits plans under ERISA, and they could enjoy ERISA preemption because health insurance regulation is preempted by ERISA. And so they moved their battle under ERISA, and these rules aren't applicable. And so this is my Mercer Law Review article that talks about this same topic in the context of the ERISA plans. Call it the elephant in the courtroom. Do you need to talk to me?
I do. Well, not really to you, but to the videotape. For those of you watching on tape, the first attendance verification code for today's course is LRI, as in Lien Resolution Institution 234. LRI 234. I'm going to interrupt you like 4 times over the course.
Okay. You guys make this difficult, don't you? So that's what we have, is this battle now has moved into the context of the federal courts because of ERISA preemption. And like I say, my current foray is, and I still carry with me all of the other tools that we've developed, and there's many of them, is to look at the choice of law provisions and plan documents and see whether or not they purport to apply some state's law in the absence of federal law. I still think we have a good argument there. FMC versus Holiday, to me, this is the single most important Supreme Court decision in this area. And in this case, which arose in Pennsylvania, the court allowed reimbursement, but the court held specifically that if this was an insurance company providing insurance to this plan or its beneficiaries, that Pennsylvania law, which prohibited subrogation, would be applied. And it's an application of the saving clause. And the language that I find just it's still there. I would say 99% of every attorney I talk to involved in this area of law is not even cognizant of this language. It's never been retreated upon, never been overruled, never been modified by the Supreme Court. And I'm taking the important language in bold there. An insurance company that insures a plan remains an insurer for purposes of state laws. The ERISA plan is consequently bound by state insurance regulations insofar as they apply to the plan's insurer. Now, those of you who follow ERISA, you know that the most devastating case in terms of federal preemption is the Davila case. That came along and it now started talking about complete preemption, which is a species beyond the statute. And it dealt with the tort action they were trying to foster. The Davila case does not even cite FMC versus Holiday. This language remains sacrosanct in the books. And I did some thorough research. When I worked with my attorney friend in Honolulu, he didn't even cite FMC versus Holiday in his brief. And I said, you need to cite this case. And this case should be cited on page 1 and use this language. Because that's what they had, a fully insured plan in Hawaii, and under FMC versus Holiday and under the saving clause, state law applied, end of discussion. Well, I did get him to cite it in the brief, and now it got included in the brief and in the opinion. But that to me is the most important aspect of the saving clause. And so we do now, as one principle, we have, if we have a fully insured health plan, in other words, a health plan which is covered completely by United Healthcare, by what are some of these other ones? Anthem. I don't know if Anthem is the one in California. If you have a fully insured plan, the law should be 100% clear. The state law concerning subrogation controls. And we have the decision of Wirtz versus Rawling out of the Second Circuit, New York, that follows that. And then now the Ninth Circuit case out of Hawaii that stands for that proposition. Of course, you see, generally speaking, you have a spectrum. You have fully insured plans, you apply state law to decide whether or not subrogation is allowed. And then on the other end, you have plans that are supposedly entirely self-insured. And they use the word self-funded. I hate that phrase. There's nothing more deceptive than the phrase self-funding, because I don't know of a single plan that's not insured to some degree. But when they use the term self-funded, it gives you it implies that there's no insurance involved. And the plans are very skillful at hiding insurance. They don't have to disclose that. And the documents they give you, they'll say it's self-funded and blah, blah, blah. So, but if it's fully insured, you apply state law. We also have, and I have been consistent on this, one of the major vehicles for protection by an ERISA plan is a stop-loss policy. And so these stop-loss insurance policies, there is limited authority. I'd like to me it's black and white, but I can only tell you there's limited authority that stop-loss insurers are controlled by state law. I have a Connecticut opinion by a federal judge. It's not reported, but I'll be happy to send you a copy of it. And I have an Oregon Federal District Court that specifically holds a stop-loss insurer is controlled by state law. In that case, it would be Oregon. And there's a couple decisions by state Supreme Courts. In each one of these decisions in Iowa and Texas, the state Supreme Court holds that a stop-loss insurer has to also comply with the state insurance regulations. Now, you know, this stop-loss insurer, it's like a deductible, only they call it an attachment point. And so the way that works is, and there's two different types of attachment points. I don't want to get into too much detail, but one attachment point is that the stop-loss insurer only kicks in above $50,000. So if you have medical bills of $200,000, the plan pays the first $50,000 and the stop-loss insurer pays $150,000. And so it should be that the efforts of the stop-loss insurer to subrogate should be controlled by state law for that claim for $150,000. Now, this is information that's extremely hard to find if you're just simply a plaintiff's lawyer representing a victim. But if you can find that information, that's why they don't want to tell you about it, because they want to keep the stop-loss insured. Some attachment points can be $100,000. I've seen one that's $200,000 or $300,000. Some can be $25,000. So it's a deductible, and it's called an attachment point. And then they also have what's called an aggregate attachment point. And that's if you have an employer, say the employer has 1,000 insureds, people insured. If they have an individual attachment point of $50,000 and then an aggregate point, whereas if the plan has paid medical bills for $500,000 for all the employees, then everything else is paid by that stop-loss insurer. So the obligation of a stop-loss insurer can be triggered by reaching an individual attachment point for a large number of medical bills for one individual, and also be reached by reaching an aggregate point. We got to be getting to a break point pretty soon. I'm getting tired here. All right. So health coverage. Okay, so that's just kind of a summary of what I've been talking about there. Okay, no, that's not a summary. It's real important. If you have coverage as an HMO, that's the same thing as an insurance company, and I don't even understand why, but it is. I guess I understand why. So I mean, but if you have a client that's got HMO coverage, then you should be applying state law point blank. You just should be applying state law. Supreme Court has said that in 3 major decisions, and there are lower court decisions that hold that on subrogation or reimbursement claims, and they're cited there on that slide. I knew it. Okay, we will take a break now and come back in 5 or 10 minutes. Yeah.
2 questions for you. One I wrote down.
Okay. Yeah.
What is the minimum lien amount which Rawlings or a company like that?
I don't know. I don't know.
I guess.
No, I mean, there's a point where they don't, obviously. There's a lot of them that skate by without, but once again, I've seen attorneys get into a tug of war with them and may aggravate them to do it. I've seen that happen. So if you're going that course, your best thing is just to lay low, no communication at all.
I had one with Rawlings for $16,000. I saw several letters and to start court action. I kept the money in my client and in my escrow account for a little over 6 years. And then I released it to my client. They called Rawlings called me a year after.
Get the show on the road here, and finish part 2. I've had some questions. I've kind of overwhelmed with white sheets of paper that I'm having trouble read. So I need, sometime before we get done, I need to talk about the Form 5500. The Form 5500 is filed with the United States Department of Labor. You need to say something?
Just that we're going to go. We were supposed to start this first session at 11:15. We'll go to 11:25 to give you enough time.
Okay. Yeah.
Okay.
Yeah.
Can you speak?
Okay. We're going to break at 11:20, if not before, depending on what I want to say. Form 5500s are filed by most ERISA plans, not all of them, with the United States Department of Labor. I am a registered user on the United States Department of Labor website. I kept asking for forms, and they said, we'll make you a registered user. So I can do searches on there. The searchers are incredible. I get Form 5500s that go back many, many, many years. A lot of attorneys use what's called freeerisa.com, and that's a resource. When you print it out, it says freeerisa.com, so it kind of looks cheesy. But I can get the real thing for you by logging on to the United States Department of Labor website. And I make a habit to do free searches for people. So if you have something you want me to look up, the most important research tool I have on that is the employer ID number, but I can do other searches on that. There's a funny little thing there. Let's see. I went to the United States Supreme Court in 2006 in the Sereboff case. I worked with the primary attorney was from San Francisco, and the attorney that handled everything in the Supreme Court is Peter Striss. And the picture in the middle is me with Peter Striss and the primary, Jack something, I can't remember his last name. I'm getting old. And the picture on the left, that's the clerk of the Supreme Court, General William Souter. I had to get a personal invitation to the clerk's office, and there's that picture, and that's my daughter, who's a lawyer, in the pink there, in the hot pink. So that's the Supreme Court. Peter Striss is an amazing litigant. He's taken on and handled many oral cases and oral arguments in the Supreme Court. He strives to do that. He takes on cases other than ERISA cases, but he's taken on several ERISA cases. He was successful. We weren't successful in Sereboff. The decision was unanimous and we lost. So But he was an amazing person to meet. He won the LaRue case, which reversed both the Fourth Circuit and the lower court. As an ERISA issue not related to what I do. I got to know Peter real well. I brought him to South Dakota for an ERISA symposium that we had a few years later. He was a great speaker. Students loved him. He's a very dynamic person, and I would call him a friend of mine. Now, he does other things. And so in a more recent controversy, he was the attorney representing Karen McDougal, the former Playboy playmate who had a relationship with Donald Trump. And so I turned it on TV and I seen Peter Striss on all the cable news channels representing Karen McDougal. So he's a fascinating person. If anybody said, who's your number one recommendation for any kind of ERISA litigation in the Supreme Court, I'd say Peter. So there we go. Another famous person. These photos were taken over 49 years ago. My brother and I grew up in Jefferson City, Missouri, and I first came to New York when he got appointed to be West Point. And so he went to West Point, and I came in the summer of 1986 and then again in the summer of 1970. And he decided to stay here. So he found a girl in Long Island, married her, and stayed here, and this is why we come out. And today he is a very successful intellectual property lawyer with his office here about, I think he said 3 miles away. And so Paul was kind enough to arrange this Mellville location so I could be close to my brother. He's also going to be my ride home after the event. Please pick up some bling. I got it over there. Got the bags. Each of the little white envelopes has a magnetic calendar on it. There's a whole bunch of those sectos. We got pins and other things. And my joke for part 2. The journalists were interviewing Molly Holderness, who's 103 years old. They said, tell Miss Holderness, tell us, what do you think is the best thing about being 103? She smiled and said, no peer pressure. You can relate to that. All right. I want to talk about, and then we're going to have the Q&A, and some of your questions or situations are just too overwhelming. I'm not going to be able to answer them, but I'm going to try to provide a product that's useful for most of us anyway in the Q&A. A couple of provisions I want to talk about, the anti-annulment provisions. There's very little law on this, and I've been making this argument for over a decade, and one of these days a court's going to buy it. And I'm hoping that the United States District Judge in Seattle is going to buy this argument. Part of this is being able to articulate it in the best possible way, and I think each time I articulate this argument and I lose, I figure out how to articulate it in a better way. And there's really not any published opinions against it. They just ignore it because they think it's that bad, I guess. I don't know. Anti-annulment, there's 2 provisions in ERISA that says plan assets have to be utilized for the benefit of the participants and beneficiaries and cannot be utilized for an employer. Cannot be used, and there's also a provision that prohibits self-dealing. And so my argument is that when you go after a subrogated recovery, that becomes a plan asset. And if you find out how this really works, what happens to these subrogated recoveries after you pay off Rawlings and after you pay off the collection attorneys who's representing them, the remainder is just turned over to the employer, and it's paid back to the employer, who may, if he wishes, continue to operate a health plan and may use that to lower the cost of operating the health plan in future years. It does not go to the benefit of the pool of insureds who were insured at the time the accident happened. So in other words, when a health risk is analyzed on an actuarial basis, and I'm sat on the board of directors for an insurance company for years. When a health risk is analyzed, an actuary says, okay, this is how much we need to collect as a premium, whether it's self-funded or self-insured or insured. This is your premium, and you have to take that in consideration. And subrogated recoveries have always been a windfall. They don't affect rates. There's case after case, authority after authority says subrogated recoveries are not affected in the rates. And so the handling of a subrogated recovery is simply an asset for the employer. But it's a very sophisticated argument. Sometimes you don't get a lot of ability in federal court the way, I mean, first of all, discovery is virtually non-existent in ERISA cases. I mean, it can happen, but it's very difficult. These people are so hard to deal with. And what you finally get when you go through the discovery is meaningless. But I'm working on this argument. I'm hoping this federal judge in Seattle is going to agree with me on that. It's there. And I know I've talked to Paul Isaac, and he's been, I was in a case, we took the deposition of the main guy, the plan administrator. Okay, here's a question. I need to answer this question, everybody. When you deal with an ERISA plan, you have a plan sponsor, you have a plan administrator, and you have a claims administrator. The plan sponsor is 99% of the time the employer. It is the plan sponsor. Who's sponsoring the plan? The plan administrator is 98.5% of the time the employer. By statute, unless it's designated otherwise, the plan administrator is by default the plan sponsor. So when you're dealing with an ERISA plan and you want to know who the plan sponsor and the plan administrator is, and in virtually every case, now there's some variations, some of these union plans and so on, but in most cases, it's the employer. And your remedy under the ERISA statutes is you have to deal with the plan administrator. The terms get confusing because the plans will set up a claims administrator, which is an insurance company. And so you'll have an insurance company, United Healthcare, or Cigna, or Anthem, or somebody, and all they do is they administrate claims, and they're not insured on any risk. Well, that's what they say. But if they are insured on any of the risk, it's hidden, unless it's fully insured. And if it's hidden as stop loss. And that's the problem. How do you define that out? I don't have an easy answer for that. I have an associate that I work with. She worked in HR for 20 years. She used to work with ERISA plans, and she actually filed the Form 5500s that are filed with the Department of Labor. And you can gain insight by looking at these forms. And if you come to me and say, how do I determine if this is a self-funded plan or partially insured plan, I can tell you everything I know. I can help you maybe find something that might be close to an answer, but then I'll turn it over to Marilyn and I'll ask her to do it, and she'll come up with stuff that I didn't see. And neither one of us can guarantee you an answer because it's so well hidden. The Form 5500s, if you've seen them, you see there's a place on there where they say, how is this funded? And there's different boxes you check, and one of the boxes is insurance. And if it's funded by insurance, then you think, aha, I have an insured plan. And every time that happens, they tell you it's not insured. And there's case law out there that says the Form 5500 is superficial, it's just a form filed with the government, and you can't rely on it. Well, okay. But that's the only thing we have to go on. So even though the indicia that we have is not reliable, it's the only indicia we can pursue. By far, and I gave this in response to a question up here, I want to share it with the audience, by far the most valuable resource for information is your client, is to go to the HR department. And hopefully, whether there's a lawsuit pending or anything, it doesn't matter. If HR people are doing what they're supposed to do, they're going to give you the client the information. And these plans are required to give a summary plan description every 5 years and hard copy to your client. And if you have a client that hangs on to documents, that's great. A lot of the cases we've been involved in, the plans, like the Wells Fargo plan, some of these other ones, where I worked at the University of South Dakota, what are my benefits? Okay, I'm an employee. I go to this special website that only I can get into. It's not internet, it's intranet. And in this website, I have my credentials, my login, and my password. And so I can go in there and find out a lot about my plan. So as an attorney representing an injured person, I say, I'm your attorney, give me your login information, and we'll go look at it for you. And so myself or Marilyn, we'll gain access to these plans, and we'll get information that way. I'll guarantee you 100% the information you get through your client or through the website or through HR. A lot of times HR is very, very sympathetic to the situation. They'll help you. The information you get there is reliable, 100%. The information you get from the subrogation attorneys, the collectors, Rawlings, Anthem, all these other ones, Optum, the information from Xerox, the information you get there is not reliable. And the reason it's not reliable, and I know these guys who work on the other side that now come over to our side, we just made things up and told them. There's no remedy. They can misrepresent facts about the plan because you can't sue them. If you think you have a state law cause of action then for misrepresentation or falseness or whatever, for improper bill collection, that's all preempted by ERISA. So as long as they're doing work for an ERISA plan, they can act with impunity. And I just categorically, I don't try to insult him, but I wouldn't mind insulting him. I don't try to insult him, I just don't rely on anything given him. And we were in a case once in St. Louis where we asked for, where they gave us voluntarily 3 plan documents. And I didn't pick this up, but Marilyn did, because she knows these things, 3 different things, a Form 5500, something. And each one was from a different plan. It's from 3 different plans, not even the plan involved. There were related plans. It was like, oh, this is the retirees plan, and this is the such and such a plan. But she says, your documents aren't even from the same plan. So in any event, I digress. Fiduciary is prohibited from self-dealing. There is a protocol under ERISA. It's one of the few tools we have, is you can prepare a request for documents and serve it on the plan administrator, not the claims administrator, not Rawlings, but you serve it on the plan administrator, and you have to find out who that is, and anything you got will probably identify that, and it's almost always the employer. And you want to do that because you want to have a line of communication with the employer anyway. But if you don't serve it on the plan administrator, there's no remedy. There might be, but it's a big gamble. Some courts have said if you serve the claims administrator, you might have a remedy. But you want to do it the way the statute says to do it. So it has to be signed by the participant or beneficiary, and you serve it on the plan administrator. And so we prepare them, and if they fail to comply with the request for documents, they can be subject to penalties of up to $110 per day per document per requester. So we always find out how many people there are. If it's a husband that's employed and he's got a wife that's employed, we have them both sign the request. So we have the opportunity to run the cause of action for penalties to be double. And the court can also grant other relief. And my argument has been repeatedly in filings that other relief can be a denial of the subrogation claim if they don't give us the information. Several years ago, I wrote an article. Marilyn really ought to be a co-author because she did so much work on it. But I wrote an article on the service of property. This tells you how to do that. I'll be glad to email you a copy of this article. It's also on my website. It tells you how to do that. It talks about the definitions of plan administrator, claims administrator, and so forth. Okay. This is a case. Attorney in Kansas City got me on board very early. It's a medical malpractice case. At the time he hired me, he had just taken the client, and Missouri had a statutory cap of medical malpractice of like $500,000. Plaintiff's lawyers thought the Missouri Supreme Court was going to set it aside as constitutional. Missouri Supreme Court did, and so his case became awesome after that. It was what we call a sharp bowel case, and the poor client didn't live long after we resolved all these issues. But I prepared this, Marilyn and I prepared this request for plan documents. We served it on the plan administrator, which is a small town employer out of Iowa, although the employees were down in Kansas City. And I can't see the dates, but if you look at the dates, we served the request for production of documents in 2012. He went through his deal. They never answered, just ignored it. I think he might have served the second one. Nothing, nada, nothing. And so he went through and he got this big settlement coming in mediation. He said, what are we going to do? And I said, well, we're filing a lawsuit in federal court. We tried to get a state court judge to enter an order to show cause. He didn't do that. So we filed a lawsuit in federal court as a plaintiff. And of course, one of our counts is, main issue is, for reasons set forth, the plan document is not enforceable, and I've got a whole bunch of reasons I'll give you for that. One's unconstitutional, one's anti-inurement. But we had this huge count for failure to comply with this request for documents. And Marilyn made a spreadsheet, and for the documents that we requested, and you can see we had it signed by both the lady who had the short bowel syndrome, which is a horrible thing, and her husband. The spreadsheet had the maximum well over $1 million because they just totally ignored that. And we asked for many of these, there's lots of documents. She knew Marilyn knows what kinds of documents to ask for, and so that's what we put in the request. And so that lawyer was so happy. I kept my time on an hourly basis, and we got this lien whittled down to, we got like, I don't know, 600,000 chopped off of it or something. And he says, Roger, I don't care what your time sheet is, you're getting 6 figures on this. And he sent me a check for $100,000 just for my work on that. But that case came in when it came to me when it came in his door. And I could set the stage and lay the groundwork so we could be effective. This other case I've got this Wells Fargo case is also a medical malpractice case, and the lawyer who I love dearly, he didn't contact me till he had the settlement. And I said, we got to serve a request for document. And he said, no, let's not do that yet. I'm not sure about the settlement. And he wouldn't even let us contact the client to do the request for, and then finally, like a month and a half after he got me on the file, he lets us send the request for documents, and then 5 days later, he says, I got to close this. What are we going to do? And I don't have any of the documents. I don't have a cause of action for not complying with the request. And at the last minute, we found the plan document that incorporates Minnesota law. So I don't know what's going to happen there. But my tools are a lot less in that case than they were in this case out of Kansas City, that medical malpractice case. I say be assertive in choosing the form and the issues. What happens traditionally, the ERISA plan sues the lawyer and the client in federal court because they breached the terms of the plan document, and they win 90% of those cases. I mean, it's just very difficult. And they turn to me for justice. What am I going to do? You know, I'm sorry. You know, you should have come to me earlier. I don't mean to be a prick. It's just you don't. There's no posture. There's nothing you can do for these people when they're hauled into. It's like a criminal defendant. You breached the terms of the plan document. Doesn't the document say you need to do this, and you didn't do it? What's the defense for that? Plus, some federal judges don't like plaintiffs' lawyers. You know. So I say I'm going to have to just skip through these because I say it in there about 5 times. Every case where I've filed the suit as a plaintiff in federal court has been, I mean, not necessarily a total victory, but we've never suffered anything adverse. We've always gotten a really, really good result. And it's usually come pretty quickly because the other side knows that they either have to deal with us and be reasonable. So I don't want to wait around to be sued. I become the plaintiff. I represent the plaintiff in federal court and sue. Much more effective that way. Here's something that I found. I taught civil procedure for 30 years. This statistic is amazing to me, and it's repeated over and over again. Plaintiffs who file civil lawsuits in federal court win 58% of the cases. Flat out statistics, point blank. Plaintiffs who file lawsuits in state court but are removed to federal court win 38% of the time. Huge difference. It's just flat out statistics. So, and I see that. I mean, a plaintiff who goes to federal court and goes to state court, gets removed to federal court, they're usually up there, oh my gosh, how did I get up here? What happened? I didn't see this coming. And I worked with a lot of lawyers who try to bring ERISA plans into state court the wrong way and just sue them. And if you sue them in state court, it's removable, and you fall into that latter category. I'm not saying don't go to state court. You can go there, but you have to go there in a smart way. And so my personal success rate is really 100% for every case that I've filed in federal. And in terms of representing those attorneys and their clients that get sued in federal court, the ones I've gotten involved in, I've had some successes, you know, but I'm talking about 40, 50%, you know, maybe 50, 60%. But those are definitely difficult cases. Okay. Got that. All right, here's the ERISA statute that gives concurrent jurisdiction to state court. This is what we relied on. The first thing, well, war story, I don't want to get bogged down there. The federal statute allows state courts to bring an action for clarification of rights. And so state courts clearly have concurrent jurisdiction. But if you don't bring them into state court the right way, now a lot of times you can bring them in as a settlement for minors, and you bring a party in, don't name them as a defendant, but you bring them in to participate in the settlement of minors. That's the way you can get them in there, and the state court has jurisdiction to resolve the enforceability of the ERISA subrogation claim. The general train of thought is that the state courts are going to be more sympathetic and willing to not enforce that language than federal courts. So generally, you assume that state courts, especially a state court dealing with a minor, that's a special area of the law. Special situations, there is a body of law, it's not huge, but there's a body of law where they don't apply ERISA preemption for minors. And I just think when you look at, it's one thing for an adult to be injured, but when a minor's injured and you're going to take away all of the recovery for this catastrophic injury, so there is a body of law, including the highest authority is a denial of petition for writ of cert to the Fifth Circuit, where the state court was able to, even though it was able to ignore the ERISA claim. Also, special situations on causation involving medical malpractice. The most common scenario is failure to diagnose. Doctor fails to diagnose cancer. So you got a bunch of bills related to cancer. You got a bunch of bills. Where do you draw the line? You draw the line. First of all, the ERISA plans probably don't even know you have a tort action. And so they're very much surprised when they find out. And sometimes you have to kind of tell them there's a tort action even though you don't want to. But when you have a tort action, and then the minute they find out there's a tort action, then they claim that every bill related to that cancer is related to the malpractice. So that's just a special situation there you got to deal with. Some states like South Dakota is not very friendly, and so.
Code, sorry. I was trying to not interrupt you in the middle,
That's
but
fine.
I failed. For those of you watching on tape, the second attendance verification code is LRI, as in Lien Resolution Institution 873. That's LRI 873.
Thank
Keep
you,
going.
Ashley.
You're rocking it.
Okay, so sometimes the federal arguments are better than the state arguments, so just put that out there. There's a plan document issue, and I can really get bogged down here, I don't want to. The federal statute requires plans have a plan document and a summary plan description. Two separate documents. Cigna versus Amera, a 2012 Supreme Court decision, holds specifically, and it's just enforcing the terms of the statute. The terms of a summary plan description are not enforceable under ERISA. Almost all your reimbursement provisions are in a summary plan description and not in the plan or may or may not be in a plan document, but are in a summary plan description. And so the case in Seattle, they're suing for a summary plan description, and one of our arguments is you can't sue for the terms of a summary plan description. That decision was reaffirmed in McCutcheon, which was a horrible case for us generally, but there's a footnote that re-emphasizes that rule. Because this case made it all the way to the Supreme Court, and they found out you're fighting over the terms of a summary plan description, you can't do that. You have to fight over the terms of a plan document. So there's a body of law. I also have an article out there on that that's available. And that's one of the reasons the Missouri court ruled in our favor also, was they were seeking to enforce the terms of a summary plan description, not the plan document. Okay. The Montanil case, that was a somewhat favorable decision. 2016, I think. I'm having trouble seeing the date. I wasn't involved in that case, but the holding is, the whole theory behind enforcing an ERISA lien, ERISA subrogation claim, is you're enforcing a lien that arises out of contract, and it's an equitable remedy. The plan can only pursue an equitable remedy. And in Montanil, what happens if the client has been given a tort recovery of $50,000 and has spent it all? The plan still tried to get the money out of the client, and the court says you can't do that. If the money's gone, you can't get, it's not, no longer remains an equitable remedy. You can't pursue the general assets of the client. And so what this stands for, in this general proposition, if the client dissipates the assets, he can't be sued anymore. And that's the holding, and that's the holding. But the court, but that rarely happens. I mean, it happens sometimes. And I'm afraid that too many lawyers rely on this too extensively and they get burned. And in this case, that's exactly what happened. The client took the money and, well, this is the language from Montanil, first of all. There's a couple slides there that has the language from Montanil. And you'll see that it talks about identifiable property, and then you get into tracing, what did you do with the money? And plans are allowed to take depositions of clients to find out, what did you do with this money? Oh, we bought a mobile home or something. And if they can trace it, then they can go after it. This should be in the printout you have also. I know some of you are straining to see that. But here's kind of a recent decision handed down in the last year or so. The client, lawyers are looking for a reason to disperse the funds, and they said, we're going to do the Montanil approach. And so the lawyer dispersed the funds. The parties took $200,000, bought a certificate of deposit, which is a savings, and then bought a van for $62,000. And then tried to claim you can't go after that. And the court says, yes, you can, as long as you can trace the assets. And it identifies, the only things that are, you have to spend the money on services, travel, or food. And so Montanil is out there. I don't think it's a strategy. I would never recommend anybody follow the Montanil strategy. But if it happens, it happens. It's going to be hard to show a dissipation of assets satisfactorily, but it's out there. All right. I want to tell you about an Arkansas. This is a case that comes up a lot, this scenario. Western District of Arkansas. We filed a lawsuit in Western District of Arkansas. This plaintiff's lawyer had a motorcycle victim, big tort recovery coming in. Plan wanted, $500,000 or so for ERISA lien, and he hadn't settled it yet. So he comes to me in the second time frame, and the attorney is communicating with him. The attorney is in Ohio, and the employer's in Arkansas, the employee's in Arkansas, the accident's in Arkansas, the plan is administered in Arkansas, the claims administrator and the plan administrator are in Arkansas. So everything's in Arkansas. But they go through Rawlings or one of these collection agencies, and they get an attorney in Ohio who's now got the subrogation claim. And he sends him this, you've probably seen this, you need to sign this document that says you're going to honor our lien. So we need you and the client both to sign this. And of course, the attorney doesn't want to sign it. And then doesn't sign it. So the lawyer says, well, if you don't sign this, I'm going to sue you in the United States District Court for Ohio. Because under ERISA, venue is wherever the plan is being administered. And since I'm trying to collect this lien, I'm trying to administer this plan in Ohio. So this attorney, Matthew somebody, tells my guy in Fort Smith, we're going to sue you in Ohio if you don't sign this document. And he said, I've done this before. So I got a hold of my head librarian back at the University of South Dakota Law School. I said, can you do a search of all these federal cases and look this guy's name up? And sure enough, he found that of the lawsuit, and he did exactly that. He sued an attorney in Missouri. The plan was in Missouri. The employer was in Missouri. The employees, everything's in Missouri, but he was trying to collect this in Ohio. And not only that, but the summary plan description put venue in Missouri. And I said, this guy's going to do this, And I called this attorney, he's in Columbia, Missouri, actually where I went to law school. He's in Columbia, Missouri, and I said, did this happen to you? And this guy told me a tale of woe I just couldn't believe. He said this Matthew, whatever his name, this attorney in Ohio, called him at 9:30. They had the same sort of thing. Sign this agreement. Funds are coming in. Sign this document. You're going to agree to do this. And if you don't do it, we're going to sue you. So as this progressed, this attorney called him at 9:30 at night and said, I just sued you in federal court, and the federal judge is going to have a hearing on a TRO tomorrow morning at 8 o'clock. So this guy's in his office, and he gets a phone call from somebody for this federal judge. And so he tells his paralegal to tell him he's not available. So his paralegal responds to this phone call and says, Mr. whatever this attorney's name is, he's not available. Well, judge doesn't like that. So he's going to have a contempt hearing on the veracity of him not being available. So the judge schedules a contempt hearing in Ohio. So the guy in Columbia tries to hire local counsel in Ohio to defend him, and the judge says, you're either going to be here in person with your paralegal, or I will send a federal marshal to get you. So this guy has to go from Columbia, Missouri with his paralegal to Ohio. Plus he hires local counsel, spends $20,000 for local counsel. Plus his attorney, his paralegal's afraid to fly, so they have to drive there and back. They go to court, the judge chews him out, his paralegal's crying in the courtroom, and fines him for doing this. Okay, true story. I mean, this guy, he talked to me on the phone for a long time because this was not a pleasant thing. So I go back to my guy in Fort Smith, and I said, this is what happened to this guy in Columbia. So what do you do when that happens? I said, we need to sue him. We need to sue him in federal court. That's Roger's philosophy. Be the plaintiff in federal court. So he doesn't follow my advice, and he sues him in state court as a defendant. And so the guy said, well, we're going to remove this to federal court. And the guy in Arkansas, he says, I don't want to go to federal court. I don't like federal court. I like state court. Nobody likes federal court, well, sometimes. And so I don't want to go to federal court. I said, well, he's going to he says, how can we remove this? There's not diversity. I said, there doesn't need to be diversity. It's removable as an arising under case. This is an ERISA case. It's removable to federal court. He's going to remove it to federal court. My advice to you is dismiss your state court action and refile in federal court. So he follows my advice. So he dismisses that, and within 5 days after that attorney's final threat of suing him in Ohio, we sue him in Arkansas federal court. So we've got a lawsuit there. I'll be glad to send you the complaint. It's on record. So we sued him in Arkansas state court. I allege how this guy's going to sue in Ohio, so we'll at least let the Arkansas judge know what shenanigans are playing. And within 30 days, it's settled. So now I did get a follow-up. For what it's worth, I don't know. This Columbia attorney that got hammered by that guy in Ohio, it's true. ERISA is nationwide venue, also nationwide service of process, venue wherever the plan's administrated, his theory. He said this fella's fiance, clerk for this federal court, and that's why he might have had an insight. But you know, that happens. You need to play the game. Okay, I think I'm ready for Q&A.